Good morning. Happy Thursday. Several people asked me to talk about ex parte communications with judges by non parties. And why not? It's not very interesting, but if you're interested in this kind of thing, maybe you'll like it. We've seen a lot of ex parte communications from non parties or attempts at it by First Amendment auditors. They will pass out phone numbers for judges, they will pass out addresses, etc., hoping that they can get the people watching their videos and live streams to call flood the judge. Because why not? I mean, it may even be a crime to do that, but that would depend on the state. I don't recommend doing it. But anyway, what they don't understand is that calling the number for a judge, like you could go on to, for example, the Sacramento County Superior Court website, and you could look up the judicial phone directory. You could find the numbers for all the judges. Thing is that the judge won't answer the phone. You're going to get the judge's clerk. The number actually rings to the judge's court, and you're going to get a bailiff or a court clerk answering the phone, and they're not just going to hand it over to the judge. They won't do that. You don't get to just call up the judge. So a lot of that is going to be screened very quickly and very effectively. So what happened recently was, in case you're not aware of it, OG2 Jonathan Green was arrested for driving down the road with loaded firearms in his vehicle. I believe he had a pistol and a rifle. And he was arrested on 2 felony firearms charges. He apparently at one point in time had a carry permit for Ohio, but he had let it lapse because he's just not a very responsible person, apparently. And so he was facing a couple felonies, 1 felony for each firearm. And someone whose handwriting looked suspiciously like Dougie's handwriting, whom you may know as Auditor Truth, the fine fellow who was handing out warning flyers done in apparently crayon at an open carry Texas rally, trying to warn people that Earl David Worden was a convicted rapist. Well, someone with his handwriting wrote a letter to the judge complaining about something. I didn't even really read the letter. The penmanship was just horrible, and it wasn't worth reading. Apparently, he was complaining something about that Mr. Green hadn't sought intervention for a drug problem or something. I'm not entirely aware of it. Don't really care. And so what the judge did is, apparently the judge stamped it as read and then sent it to the parties. Now, why? And of course, in Ohio, judges aren't supposed to accept ex parte communications from third parties. They aren't supposed to consider it. They're not supposed to receive it, and they're not supposed to consider it. So what did that particular ex parte communication do? Well, it may have biased the judge. And if it did bias the judge, then maybe Mr. Green, who has apparently pled guilty to both counts, maybe he can get a whole new hearing. Maybe not. It would depend. He'll, of course, have to talk about that with his attorney. It may expose the judge himself to some sort of reprimand from the bar, or otherwise, maybe from like I don't know exactly how they do it in Ohio. Maybe it's from the Supreme Court or a bar association or some other government agency, whoever oversees judges there. But ultimately, at the end of the day, it is subverting our system of government. Our system of justice. If you're a fan of our system of justice, well, you have good taste. While our system of justice is not perfect, it is the best system of justice that has been designed so far by humans. There are other systems of justice out there. I know in Europe, they tend to have models where the judge takes an active role in the investigation and actually directs the course of the investigation and the charges and things like that. You also see a lot of that in communist style systems where the judges have a lot of leeway to go beyond the bounds of what we would allow to find evidence, to do investigations, to direct people to things that they think are going to sway it. But you could already see the conflict coming there. If a judge thinks a particular thing might be more persuasive than other things, then of course you're going to go look for that. Whereas if you don't know what the judge is going to find particularly persuasive, then you're going to just put on the best case you can. But ultimately, at the end of the day, what our system is designed to do, it's designed to protect the finder of fact, be that the judge or the jury. It's supposed to protect the finder of fact from tainted evidence, from evidence that is unreliable or obtained in violation of your constitutional rights, or is otherwise lacking in probative value, things that are irrelevant. For example, you can't when you're trying to convict someone, you can't say, Bob here is on trial for burglary, and Bob was convicted 10 years ago for rape. You can't do that because that's more prejudicial than probative. You can introduce evidence of Bob doing similar crimes. Like if you said, Bob's on trial for burglary, you could introduce evidence of Bob being convicted for robbery and Bob being convicted for breaking and entering of some other sort. Other things that are like the charge that he is currently facing, to show a habit that he tends to do those kinds of things, so it's more likely that he's doing it. You could also introduce evidence of crimes of moral turpitude, where you show that, Bob's been convicted of perjury, so you can't trust what Bob's saying. Sure, but you can't just throw stuff out there just to smear Bob. Whatever you're introducing in court has to be relevant. It has to be more probative than prejudicial. And it has to have some indicia of trustworthiness. And those things all have to come together in order for you to be able to introduce it in court into the knowledge of the trier of fact. And there's a reason why they do motions in limine, motions before the trial, to exclude evidence. And that's so that somebody can't just introduce evidence that is otherwise inadmissible and taint the jury. Because, the judge can say all day long, disregard that evidence, disregard what he just said, but people don't tend to remember that. They tend to remember the actual fact and not that they're supposed to not consider that fact. And so that's why they do motions in limine. It's to keep that stuff from tainting the finder of fact. And that's also why judges aren't supposed to receive any ex parte communications. They're not supposed to read newspaper articles about whatever case they're trying. They're not supposed to watch TV shows about whatever case they're trying. They're supposed to get all of their evidence, all of their facts from the parties. Well, excuse me, not all of the facts. They're supposed to get all of the contested facts from the parties. That way, each party has had an opportunity to see the facts. That's what discovery is for. Each party has had an opportunity to do whatever tests they need to do to figure out whether those particular facts are reliable. Each party's had an opportunity to find contradictory evidence or exculpatory evidence to mitigate some of those. Each party's had just opportunities to make sure that whatever evidence gets in front of the court is as reliable and trustworthy as possible. So by trying to circumvent that, you're really tainting the whole process. Now, other people have asked about amicus curiae briefs. Basically, friends of the court can submit briefs And friends of the court is a nebulous term. It just means that they're non-parties who submit briefs. I've never dealt with an amicus curiae brief, but my understanding is that in California, as well as in the federal system, you have to seek leave of court. I know in the federal rules of civil procedure, you have to actually, unless you're the government, the United States government can always submit an amicus brief, but unless you're the United States government, you have to get permission from the court to file the brief. And the way that you do that is you file a motion to have the brief read by the court, and you file that with the brief. The judge will make a ruling on whether or not to allow the amicus brief in, and if he allows it, he'll read the brief. If he doesn't allow it, he won't read the brief. But there's also various controls over amicus briefs. You can't brief things that weren't raised by the parties, things like that. You can't establish facts in them. You have to go by the factual record that was established at trial. And that's another. Interestingly enough, that's what's going on with the Flynn case. That's what makes the Flynn case so shocking to me. Was at the last hearing where the judge had an amicus who the judge had requested to argue against the position that both the government and General Flynn's attorney took. The judge also was taking into consideration and accepting as facts letters and news articles that he had received ex parte from outside of the trial, outside of the scope of the record, which is shocking to me. And I am somewhat, I'm not going to say upset, but I'm disappointed that a sitting district court judge would be so fast and loose with the rules of evidence. And maybe it has to do with the fact that that federal district judges are appointed for life, and there is no real oversight to them unless they get impeached. So anyway, that's the difference between an amicus brief and just writing an unsolicited letter directly to the judge. What judges normally do is they normally will send those letters to the parties, and the parties can do with them as they will. The letter is not, a letter like that is not something that you can just introduce as evidence, even if you get it as a party. You'd still have to establish all the facts in it. You'd have to authenticate the letter. You'd have to authenticate, or you'd have to get the writer of the letter in there to show that the writer had some firsthand knowledge of these things, and he's not just some crackpot out of Texas who sniffs the markers too much. Anyway, I've rambled long enough. I apologize for the quality of this one, but it's something that people wanted me to talk about that I'm not really too animated about. So you get what you get. Thanks for watching. Have a great day.